Hello, everyone. My name is Donna Hicks, and I want to welcome you to the seminar, the Herbert C. Kelman Seminar. And first of all, we want to thank you all. I know people are tuning in from all over the world, some of you in the middle of the night. So thank you very much for joining us here today. We have an unusual seminar for the Kelman, at least the Kelman seminar. This is unusual for us. We don't typically have a panel. But today we certainly have 4 or 5 voices actually that are going to be sharing some remarkable work that they're doing. And the session will be recorded. We're doing recording right now. So if for some reason you want to review this and see it again in a few days' time, check out the Program on Negotiation website. But because we have so many wonderful speakers here, I'm going to be very brief here, but I do want to give you a background in what this session is about. So today's seminar is going to touch on the topic of the rights of nature movement and how to use the reframing of our relationship to nature to understand past conflicts and hopefully create a new way of relating and understanding how to resolve issues that are resource and environment relationships. So the rights of nature movement is referred to by a recent UN report as the fastest growing legal movement of the 21st century. Honestly, the fastest growing legal movement. So we are on the cutting edge here today with this wonderful panel. So there's nearly 400 active cases. And considering nature, what they do is they consider nature as a legal person or living entity. And as you might imagine, it has the potential to have really powerful impact in reframing how we see nature, how we experience it, not as a resource, but as an entity that we relate to and which we aspire to live with in harmony. This relates to the fascinating conversation we had last month with Dr. Paul Arthur Berkman, where through the topic of science diplomacy, we explored the importance of this relationality and process to find common ground in these resource conflicts. The recognition of the rights of nature offers a paradigm shift opportunity where such relationality becomes ever more present. And so we're in luck today because Paul Arthur Berkman has agreed to come and create a kind of a segue between what he spoke about last month and what we're talking about today. And what, in particular, the concept of science diplomacy, and also a project that he was very involved with the Indigenous Youth Summit, where they're empowering new generations of young people who are taking very, profound action in trying to create a sustainable future. So first, I'm going to just turn this over to Paul. Again, he is a fellow at the International Science Council, for those of you who didn't see him last month, but also a Program on Negotiation fellow. So, and after Paul is just going to give a brief introduction, a bridge between his work and what's happening here with these remarkable women, we're going to have 4 panelists. We're going to have Gabriela Anslaba Bejarano, who is a sustainability specialist. We have Erin Matariki-Carr, a researcher and facilitator. She co-leads the River Revitalizing Indigenous Virtues for Earth's Regeneration. And she's a research fellow at the University of Auckland. Erin O'Donnell, who is a senior lecturer and research fellow at the University of Melbourne Law School. And finally, we have Lydia Cano, who is a legal advisor and consultant and PhD candidate at the Massachusetts Institute of Technology. And in all fairness, we have to say she was the moving force behind the creation of this panel. So we want to give a special thanks to Lydia. All right, Paul, it's yours.
Thank you very much, Donna, and the Weatherhead Center for the opportunity to convene this 2-seminar series. I'm going to just briefly provide comments, but first I'd like to say I live in Falmouth, Massachusetts. on the lands of the Mashpee Wampanoag, who are the traditional guardians of the associated ecosystems on land and in the surrounding sea. I respect Indigenous peoples in the state, across the nation, and around the world as traditional knowledge keepers, both young and old. I honor courageous leaders past, present, and future. In the spirit of yesterday being Earth Day, this dialogue today, led by Lydia Kano Pacharoman, seems particularly appropriate. Just as a bridge, last month we talked about science diplomacy as a language of hope. In a world paralyzed significantly by fear, hope is an important solution, going back to Pandora's box. And the opportunity to have this discussion today is one of hope, to look forward into the future and to build common interests rather than just resolve conflicts. In this context, on the 40th anniversary of the program on negotiation last fall, there was a brief discussion with Diane Long about the Global Indigenous Youth Summit on Climate Change, which was a dialogue, a virtual dialogue by, for, and among Indigenous youth with global inclusion. This dialogue involved over 1,300 registrants from more than 112 nations across more than 88 languages and represents the passion and skills and interest of Indigenous youth around the world to contribute substantively to our sustainable development on a planetary scale. An outcome of that dialogue was a paper in Nature that was published last August, that Indigenous youth must be at the forefront of climate diplomacy. So we are indeed very fortunate for the panel that is being convened by Lydia and colleagues to consider the rights of nature and how we progress as a globally interconnected civilization, understanding our relationship at local to planetary scales involving the rights of nature. So I'll leave it at that. And just as a question, perhaps to consider throughout the panel dialogue, how can Indigenous youth leaders as bridges with cultures that have been resilient in the face of changes for millennia, how can these Indigenous youth leaders contribute as stewards on a global scale with the legal framing and implementation of the rights of nature? So Lydia, I leave it over to you, and thank you, Donna and Diane, for the opportunity to convene this seminar series.
Thank you so much, Paul, for that wonderful introduction, and Donna also for your generous words earlier. And thanks also, Paul, for helping us weaving this bridge that we are building between your fascinating seminar and today's seminar. And I will also piggyback on Paul's land acknowledgement, because we are right now in the same land. I am really thrilled to be here today, joined by these stellar colleagues and everyone that has joined us from so many parts of the world. As you have heard, in today's seminar, we're daring to explore how the rights of nature are reframing our conception and perception of what is conflict over what sometimes we refer to as natural resources or the commons. Let me share with you a few slides that will help me a little bit explain what I'm referring to. You heard a little bit about the rights of nature already from Donna, but for those of you who are not very familiar with the rights of nature, there is initiatives regarding the rights of nature spanning all continents at the moment. And you can see here kind of the representation of the 400 cases that Donna was talking about earlier across the world. And the way these rights are recognized varies across countries, varies across geographies, where sometimes natural entities are recognized rights. Sometimes the shape it takes is that they are given legal personhood. Sometimes they are recognized as living entities through the constitution, through legislation, through court rulings, or sometimes other means like local legislation. So it's not a very homogeneous movement. It is rather linked to what is happening on the ground and what is the history of a place. And this recognition is also not homogeneous in the sense that it has taken place for a variety of natural entities, including rivers, forests, lagoons, which are these three represented here because they are the focus of our panel today. But also many others, like you can see here, pollinators, salmon, plant species such as the Manumin rice, which is the one on the very right. And despite of the variety of natural entities, the way they are being recognized in the legal system, there's a common thread that we want to pick up today across all these cases. That has been that they constitute an opportunity to revisit the way we understand our relationship with nature, moving from understanding nature as this resource we live from towards a paradigm in which we live with and as part of nature. And this is an opportunity to understand reality in a different light. This is why I wanted to share this slide that kind of shows how we shade different lights as our reality. And this is actually giving us the opportunity to challenge the way Western and colonial legal systems incorporate our human relationship with nature, since in general, these systems are often built on the idea of nature being a resource at the service of humans. And challenging this conception is actually now materializing into new opportunities to reframe conflicts under a more relational way to see nature. So in today's panel, we will briefly introduce 4 cases from around the world, and we will discuss some of the implications that they have had in the reframing of existing conflicts. I will be trying to moderate the panel as well. So if you hear this sound, I don't know if you could hear it very much, but this is the bell, the UN bell of peace, and that will signal our speakers that that time is up, and the next one will move on so that we can hear from everyone today. So I will start taking you on a trip to my home country, Spain, to visit a lagoon called Mar Menor. This lagoon that you can see in this beautiful picture has been long affected by runoff, pollution from tourism, agriculture, past mining activities, and it has actually taken the ecosystem of this lagoon to the brink. This picture actually showed what happened when the levels of pollution led to an algae bloom that caused for the oxygen in the lagoon to drop to lethal levels for all living beings in the lagoon. And as the situation worsened, bottom-up efforts led to the passing of a law through a popular legislative initiative that recognized the legal personhood of the lagoon in the Spanish legal system. And this was a real breakthrough for our legal system. There were still disagreements regarding the way the lagoon should be cared for, and certain tensions emerged between environmentalists, community members, stakeholders from the agricultural and tourism sectors, etc. But actually, the process has been shifting. Seeing the lagoon as a legal person also has brought about new avenues for collaboration and conflict resolution between these actors. And it is still very new and on the works, but a lot of interesting developments are already taking place. And I just wanted to introduce you to a few of them as examples of how things are unfolding at the moment. As I said, this is a very new case, so things are still very much on the works. For starters, these tensions, already existed prior to the recognition of legal personhood, with different actors trying to push to meet their interest, but never having the Mar Menor at the table in trying to address these differences. And the recognition of the personhood has enabled the establishment of a set of representative mechanisms that are very sophisticated and that engage a broad number of stakeholders that have a special relationship to the lagoon in many ways. So this diagram just shows the system of representation that has emerged to represent the lagoon. And you can see that there is many stakeholders, and the idea is that decisions are made through consensus. Another example of what this recognition has allowed is actually a very important one regarding governance and how we navigate conflicts over what to do regarding something. And it has in particular allowed to break some of the local to national policymaking silos, establishing some pathways of collaboration between the national government and the regional and local government. So in this picture, the national, local, and regional entities are meeting with the Secretary of State, which would have never happened before. And they are sharing the strategies that are being conducted at the national level and at the regional level, but also building together an agenda to move forward, which had also not happened in the past. This picture, I really love this picture. It's another example of how people are coming together and also changing the way they see the lagoon, this lagoon where they grew up, just by this change in providing a legal personhood to the lagoon. So in this picture, you see people of all ages and different backgrounds, and they are coming together to give a hug to the lagoon. This is the third year that this hug to the lagoon is taking place. This is obviously a symbolic act, but really changes the way people are supporting the lagoon as being something or someone or an entity that they can hug, so they can relate to as being part of their lives and not just something that they use to have fun. And finally, and very quickly, just another example that portrays how there is an increasing sense of collective responsibility to care for the lagoon. There is a lot of new resources of data that are emerging through monitoring platforms, applications for your phone. And whenever there is conflict over whether the environmental rights are being upheld, this public information helps everyone to be aware of what is happening at the lagoon in real time. People can see whether there are environmental incidences, there can be reporting, and it's another way of having or increasing the sense of common responsibility to care for the lagoon. So with that example, I'm going to give the floor to my colleague, Erin. She's going to tell us a lot of exciting things about the Reframing River.
Thank you so much, Lydia. All right, now I'm hoping that this is coming through and you can all hear me. I am coming to you from Australia, so if we move quickly to the next slide, Lydia. Thank you. So I'm going to begin with an acknowledgement of country. I'm coming to you today. This slide probably says Wurundjeri Woiwurrung, which is where I live and work. Today I'm here on the lands of the Gadibanun people. So I pay my respects to their elders past and present, and I acknowledge that they've never ceded their rights to care for their lands and waters. This slide is a great place to start as well because it's got a picture of the Birrarung, which is Australia's first and so far only river to be recognised as a living entity. And I'll be speaking to that in a moment. If we move to the next slide. This picks up on some ideas that Lydia was talking about in her introduction and the different ways that rivers are being recognised around the world in law. And these differences really matter. And so before I get into the example of the Birrarung, I just wanted to spend a little bit of time talking about what kind of legal status it actually has. And so very briefly, we can see here at the top the idea of the legal person. This is an entity that has rights and powers in law, and it can go to court, it can sue and be sued, it can hold property. At the bottom of the screen there is the idea of the living entity. This is not a legally powerful form of legal status. It does not have rights. It does not have the ability to go to court necessarily. It does not have the ability to hold those rights and powers. But what it does do when we recognise a river as a living entity is start to put that focus back on the relationship, which picks up on what Lydia was saying about Mar Menor and people giving it a hug and centering that relationship. So the living being can be powerful in its own right, even though it doesn't necessarily have those legal rights and powers. Lydia, could you move to the next slide? One of the things that can happen when we start granting different status of rights to rivers is that we start to see this paradox of legal rights. And Lydia, if you can click again. What we see when rivers gain the status of a legal person particularly is that their formal protection goes up. Their ability to take action to look after themselves increases. And yet, what also happens at the same time is the human response to this new legally powerful river. And in that case, forces of complacency and conflict can actually result in environmental protection going down. People start to think, well, maybe it's not my job to protect this new legal person anymore because it has the power to do that for itself. And so they walk away from it, they step back. Another really crucial response can be when people see a legally powerful entity that has legal rights, like a legal person, they can become afraid. And so you can become very quickly entrenched into adversarial conflicts. And this is exemplified, for instance, by what has happened to Lake Erie in the United States, where legal rights were granted and then immediately overturned because farming communities sued to challenge the constitutionality of those rights because they could see them as a weapon pointed at them. So the legal person can create these increases in conflict. Moving on, please, Lydia. And that brings me to the Birrarung. The Birrarung in Australia, it's the first and so far only river to be recognised in law as a living entity. This is a river that is beloved. It flows through the heart of Melbourne, but it is quite a sick river. So in 2017, the Victorian government passed legislation to recognise this river and its lands as a single living integrated natural entity. And it created a whole new set of institutional arrangements that brought all of the various government agencies and local governments together in how they care for this river. This is also Victoria's first bilingual piece of legislation. So the Woiwurrung name for this legislation is Willip Jin Birrarung Moron, Keep the Birrarung Alive. And this was the first time that the traditional owners, the elders of the Wurundjeri Woiwurrung people, were invited to speak on the floor of Parliament. And that's what this photo is showing here. One of the things that the legislation does is to create the Birrarung Council. I'm a member of this council and a voice for the Birrarung River. It includes representation from Wurundjeri Woiwurrung and Bunurong, the peoples of the river, as well as non-Indigenous peoples. And we come together to speak for the interests of the river, to report to the minister and advise the minister, and to try and draw everyone into this relationship with the river. And if we move to the next slide, please. Some of the insights that we can draw from the Birrarung, even though it's not a particularly legally powerful form of legal status, it doesn't have the right to go to court, it doesn't have the right to own property, but we can start to see some new narratives emerging. If you could click again, please, Lydia. Historically, this has been a river that has given a lot to the city of Melbourne. We have had a strong narrative of what can we take from the river. The river continues to provide 70% of Melbourne's drinking water. It continues to support a whole lot of recreational activity. It continues to act as a stormwater drain. But what we are now seeing through this legislation is that people are asking, what do we want for the river? And there's now a legislated 50-year vision that sets out what the community expects and demands from government in the future of this river. And then slowly we are beginning to see a narrative emerge around how do we get to that future? How do we co-create that future with the river? And so the river itself is becoming a partner and a collaborator in its own management. And it helps all of us work together. So the recognition of this river as a living entity is actually breaking down those boundaries between people and nature, bringing us into partnership. It can create a space to diffuse these kinds of resource extraction conflicts and create a very different style of conversation. And I look forward to talking a little bit more about that when we get into the Q&A. Thank you very much.
Thank you so much, Erin. Gabriela is going to join us next, so I'm going to stop sharing my screen.
Thanks, Lydia, and thanks everyone and the organizers for inviting me to this seminar. I'm happy to join you today. I'm originally from Colombia. I'm based in Washington, D.C., and in the next 5 minutes, I'll try to explain a litigation case that was the first climate change and future generations case in Latin America that ended up giving rights to the Amazon ecosystem in Colombia. So this started as a case. I'm going over these slides. It's climate litigation. Basically, a group of plaintiffs who wanted to take legal action against the increase of greenhouse gas emissions in the country. We started by asking ourselves, what is the main cause of greenhouse gases? Why is this important for future generations? And who's responsible for this problem? Through our research, we found that most of greenhouse gas emissions in Colombia come from the deforestation of the Amazon rainforest. The data that we had at that time was from 2016. This case was filed in 2018. And there are many drivers for the loss of biodiversity in the Amazon rainforest. Some of them include land grabbing, crops for illicit use, illegal mineral extraction, and infrastructure. And there is something that we have, and that the Ministry of Environment and some experts have said, it is the paradox of the peace agreement. Colombia, for those of you who don't know, went through the longest armed conflict in the region. After 50 years of armed conflict, in 2016, the government signed a peace agreement with the FARC guerrilla. And this area of the country, the Amazon rainforest, that was previously unavailable for the majority of Colombians, started to see an increase of migration, which is related to the tree cover loss. So it's the paradox of peace. Somehow it was protected because most of the people couldn't access the region. As you might know, deforestation has many generates many problems to the environment. It alters the water cycle. It can lead to flooding. It can lead to the increase of greenhouse gases, and it also affects other ecosystems within the region. Basically, the water that 70% of Colombians consume every day comes from the flying rivers of the Amazon rainforest. So we are all connected, and we wanted to show the judges in Colombia that our ecosystems, it doesn't matter if you don't live in the ecosystem where deforestation is happening, all of the country is going to suffer if we don't stop deforestation. So basically, we showed the judge how climate change would affect future generations. And together with 25 plaintiffs, we sued the Colombian government because we wanted the government to take action against deforestation. This is just a photo of us a few years ago. So we basically said that as the first generation of adults to live in peace in Colombia, with our life expectancy being between 70 years and 80 years, we expected to be alive during the first climate change scenario, which would mean, for example, less water for those who live in the Andes Mountains, vector-borne diseases for those who live in the Pacific region, changes in diet for those who live in the islands. So basically, we explain how climate change is connected to human rights and how the inaction from the government was a violation to some key agreements, starting by the Paris Agreement, by some joint statements with other countries, our national constitution that states that everyone has the right to a healthy environment. And when we filed this action, I'm not going to explain much about the tutela. It's a legal action to protect fundamental rights, and provided the scientific evidence. We also told the judge that they needed some special lenses to understand our case. So we asked to interpret the facts and the evidence through the precautionary principle, intergenerational equity, participation, child's best interest, but also the principle of solidarity. Our national constitution has a list of duties that every Colombian citizen has to follow, and solidarity is one of those duties. So we offered a broad interpretation of solidarity. We mentioned that for the plaintiffs, solidarity had 3 dimensions. First, a solidarity with other humans with whom we share the same time and space. Second, solidarity with future generation. That was the main reason we were filing this case. And third, solidarity with other sentient beings and nature itself. So we weren't asking directly for the protection or the declaration of rights of nature for the Amazon. We only provided these lenses for the interpretation of our case. We filed and we had to appeal, so the case got to the Supreme Court of Justice, and we had some support from scientists who backed up the evidence we provided. Our case was solved, and the Supreme Court declared that the Colombian government had to create an action plan to stop deforestation, that there was a need for an intergenerational pact for the life of the Colombian Amazon. There was a need to update the land management plans. But what made the case known outside of Colombia is that the Supreme Court also declared, based on the principle of solidarity, that the Amazon rainforest, the part that is under Colombia's jurisdiction, is a subject of rights. And by recognizing the Amazon rainforest as a legal entity, it gave legal personhood to the ecosystem. Just to finalize, it means that the Amazon rainforest has 4 rights: to be protected, preserved, maintained, and restored. And with that, I finalize. Thanks.
Thank you so much, Gabriela. I am going to share again my screen so that Erin can share with us about Aotearoa. So you have the floor, Erin.
Here I am. Okay. Well, kia ora everybody. Ngā mihi nui kia koutou. Ko Erin Matariki katoa kuingoa. My name is Erin Matariki, and I'm calling in from Wellington in New Zealand, Aotearoa, New Zealand. From right now, it's about 4:30 in the morning, so excuse me. I just want to acknowledge the lands that I'm on. I am traveling. I am on Te Atiawa, Ngāti Toa Rangatira, and Taranaki Whānui Whenua land. And I myself am from Ngātiawa and Tūhoi tribal nations, which belong up north further than where I am now. And I'll be speaking about Tūhoi in particular. So on your screen right now, you'll see 2 mountains. These are the mountains within the boundaries of my nations, and I'll be speaking about Te Urewera. So thank you, Lydia, for driving the slides, and to all the organisers for putting this on, and ngā mihi nui kia koutou katoa. So Te Urewera is a really large rainforest that is untouched, largely, sitting at what we say the heart of the great fish of Maui. So this is the North Island of Aotearoa. The Māori name is more beautiful. It is Te Ika a Maui, the great fish of Maui, and the forest itself stays at the heart. So the forest is named Te Urewera, but is also known as Te Manawa o Te Ika a Maui, or the great heart of the fish of Maui. Just skip the next slide there. Te Urewera was declared a legal person in 2014, and this is the first time in the world that a rainforest has been given legal personhood, and this was done through a treaty settlement process with my iwi of Ngāi Tūhoi and the New Zealand government. It was a huge, decades-long process, which I won't go into now, but finished in 2014, and this was one of the results. Te Urewera Act, if you can read there on the slide, Section 11 declares Te Urewera a legal entity and vests and with rights, powers, duties, and obligations of a legal person. Basically what happened was the forest has been vested in itself. So under legislation, the forest owns itself. And then the board has been appointed to speak on behalf of the forest in order to give the forest a human element or human means of communication. On the right here, it says, deliberatively, we are resetting our human relationship and behavior towards nature. Our disconnection from Te Uruera forest has changed our humanness. We wish for its return. What's important about this is it's demonstrating that though this is in legislation, the movement, the innovation of a legal personhood status is recalling Indigenous legal systems of connection to the land. So if you go to our next slide. This calls into question what is governance and what is law? And I think this is a really important point that I can offer just to contribute alongside my fellow colleagues, Kia ora, Erin and Gabriella. We have to reconsider what law is. Law is not the Western conception of law. Law is about our relationships. How do we relate to the land and how do we relate to each other? If you skip to the next one. Yeah, so under a Western legal system, the way that we relate to the land is as an owner to a resource, as a manager to, or an owner to a property, or a manager to a resource, and therefore inherently commodifies the land and objectifies the land, and in some ways disenchants the land. She's considered an object, not something that is living. This is an anthropocentric and hierarchical view of land. And at the heart of our law is our culture and our worldview. Under a Tūhoe Indigenous legal system, and I have to say other Indigenous legal systems that I've had the privilege of learning from, we do not relate to the land as an owner to a property. We relate as a child to a mother. And this is true in our cosmology, but also biologically. Humans did come along much later than the land itself. This is a far more reciprocal and connected relationship, and it is what I would say kin-centric. So while Western conceptions can be considered anthropocentric because they center the human in the decision-making, ecocentric also centers the earth in decision-making, but implies a distinction between earth and human. And so I prefer the term kin-centric, which centers the relationship between the human and the earth, acknowledging that we are connected, that we are nature. Thanks. Next one. This is some extracts from the black and white letter of the law. The purpose of the Act, you can see in green highlighted, is the purpose is to strengthen and maintain the connection between Tūhoe and Te Uruera. That is a decolonial concept where we are recognizing that through colonization, Tūhoe was removed from and unable to engage with Te Uruera in the way that we would naturally. And so the first purpose of the Act is to reconnect that. And inherent in that touches on Paul's earlier question about centering Indigenous youth. If we center the people of the land to their land, the intimacy that those people have through generations of connection will inform how we relate and how we relate to each other, and will benefit everybody. Below that are the principles for implementing the Act. That's something you can read in your own time. Sorry. The next one. Thank you, Lydia. Oh gosh, okay. Last thing is that there's a board that's been appointed to act on behalf of Te Uruera, and if I skip to the last one, I guess in my last few seconds, I wanted to acknowledge that there's a management plan which is central to the management, and it flips resource management and provides human management for the benefit of the land. And what that acknowledges is the land's been here for a long time. Humans are, in our culture, considered the youngest child of the land, younger than the trees and the birds. And humans are the ones that need management, not the land. She knows what she's doing. We're the ones causing all the impact. We need management. So kia ora, Lydia. Thank you.
Thank you so much, Erin. That was wonderful. So now we're gonna pass to a lightning round of discussion where the speakers get to ask a question to each other. And just a reminder, you have 3 minutes in total to ask the question and the question be answered. So this is just a quick reflection on whichever question your colleague poses for you. And we're going to start with Erin O'Donnell. So we'll ask a question. Thank you.
Thank you so much. And Lydia, thank you for that. Thank you for setting all of this up. And Erin, this question is for you. And I wanted to pick up on a few of the things that you just highlighted, particularly around the opportunity that Te Aotearoa presents to bring forward Maori law and custom as approaches that are catalyzers of consensus building and that can foster belonging for everyone. But perhaps also to ask for some insight into the tensions that might also be coming through as Te Aotearoa is being implemented around priorities and timescales for making these reforms.
Kia ora, Erin. Yeah, thank you for the question. It's still very early days at the moment for Te Aotearoa, even though it was 10 years ago. We often refer to it as 10 minutes because, of course, the disconnection between Tūhoe and Te Aotearoa has been over 100 years. But we have had a case recently of the huts. There was a series of huts put into Te Aotearoa in the 1950s. She was taken from Tūhoe and became, actually earlier than that, but over time in the 1950s was declared a national park. And in that time, unilaterally, the settler government installed many, many huts, over 50 huts across the forest, the body of the forest, and these were removed by Tūhoe just two years ago. They had been dilapidated, but a lot of people were upset at the removal of the huts because they felt that was their connection and access point to the forest, because it allows for people to stay the night. And Tūhoe has had to address that. It has gone to court. And essentially what we're seeing is a clash of worldviews, and what we're requesting and relying on is communication between these two cultures. So Te Aotearoa board has the authority to remove the huts. They needed to be for safety purposes, but also because they were placed in the wrong place. For us, Te Aotearoa is our mother. Her landscape is a body, and there are parts of her body that are very intimate. And you would never go there. And so these huts that have been placed there without that scope, it needed to be addressed now that they were there. So I'll leave it there, but there's some other detail I could share later maybe. Okay, thank you. And my question is for Gabriela. Kia ora, Gabriela. My question for you is, where do you see this movement needs to focus going forward in Colombia? Thank you.
Thanks, Erin. Yeah, just very briefly, I think after 5 years since we won this case, it's important to sit down with the private sector and with the public sector and try to understand better how they are approaching nature and what tools can we offer for them to implement the rights of nature. What I've seen is that the narrative sounds great, and it's a way to include in our traditional legal system the way that many communities have approached to nature in the past. But when it comes to implement that, for example, the Amazon has the right to be maintained as a person, there is a challenge for the public sector, for the state to actually materialize that. And then for the private sector, when they're trying to develop some projects, it's also not clear what does it mean. So as a starting point, for example, in the case of the Amazon, what does it mean restoring an ecosystem and the communities that live there after 50 years of armed conflict? How much does it cost? What are the first steps that we need to take? Or for example, for the private sector, if you're going to develop a project in a specific ecosystem and you have to prepare an environmental impact assessment, what does it mean that that ecosystem has rights? So you have a dialogue with the community that lives there. Who's the voice of that ecosystem? How are you managing the restoration in the long term? for me, the next step should be along the lines of implementation of rights of nature. And I think it's my turn to ask a question. So, Lydia, I would like to ask you, what do you see as some of the pros and cons that are emerging in the Mar Menor case regarding conflict resolution?
Thanks so much for that question, Gabriela. And by the way, totally agree with what you were talking about before. This kind of a step to implementation that is happening at the moment and is delivering a lot of exciting things and also a lot of challenges for planners and public sector and the private sector as well. Although recently I learned that some companies are starting to include some natural entities in their boards and kind of experimenting with what would that mean. So I thought that was also a very interesting development in case our audience wants to follow that. But in the case of the Mar Menor, in terms of conflict resolution, I guess I see some pros in that some action is finally being taken in restoring the Mar Menor and in helping different actors to get there. But there is also some cons to consider in how this has to unfold given the constraints of the legal system in which we're trying to kind of embed this relational way of understanding nature. So, for instance, it has resulted in a number of actions in court, which makes again a paradigm that is trying to be more relational and to build consensus around what is our relationship with nature into an adversarial kind of approach, because this is the way the system is set up. You can only solve some of these problems in court. Although this, I think, is going to change as the implementation of these stakeholder engagement mechanisms that I was talking about get implemented. So it's early days, and I think there's a lot of promise, but there's still these tensions that I think will remain when we're trying to introduce this kind of more holistic paradigm into a paradigm that wasn't built and meant for this view of nature. But yeah, thanks so much for your question. And I think it's kind of related to what I wanted to ask Erin about the Birarung River, because Australia and in particular Victoria, there is a lot of issues regarding water management. There is a lot of scarcity. So I was wondering, what has it been in your opinion and also in your experience as part of the Birarung Council? Has it meant that the recognition of the Birarung River as a living entity has it translated into the de-escalation of any of the conflicts over water management?
Thank you, Lydia. Look, again, I think I'll have to say it is a little bit early days, but what we can start to see in the case of the Birarung is that it is creating a very different environment in which these conversations can take place. So water scarcity is a driving feature of water debates here in Australia as well as over in the US. And what that does is it tends to set people up as hanging on to their own rights at all cost. They tend to try and fight for what is theirs. As soon as it's scarce and as soon as the conversation is framed around how do we share this scarce resource between us, we've got to make trade-offs, then everybody starts digging their heels in. And what the opportunity of recognizing the river as a living being does is to say, well, actually, maybe we have a different conversation. We still have to make difficult choices, but instead of focusing on hanging on to my thing at all costs, we frame the conversation in a way that says, how do we work together? What is the vision that we all share for the future that we want to create? The river is part of that vision. So how do we change our mindset and make it something that we can embrace together? One of the really exciting things that's coming out of Aotearoa and work on the Wanganui River, which is another river with legal personhood and living entity status, is the idea of an abundance mindset. And I think that shift is really powerful because it says to people, how do we all achieve abundance together rather than how do we just defend what we think is ours right now?
Yes, completely. And it really same relates to this kind of approach of abundance versus confrontation over the resources or over or in the way we see nature. So we're gonna open the floor. We have 10 minutes and yeah, Donna, go ahead.
Yeah, well, thank you all. Thank you all very much. I mean, I don't even know where to begin. There's so many interesting things to explore in this new paradigm shift that I'm just overwhelmed in a good way, believe me, in a good way. But our partner, Paul Arthur Berkman, wanted to really address the issue of the Indigenous youth. And there's a question in the Q&A that actually kind of summarizes what Paul's interests were. So Paul, I'm going to read this this question. It says, granting legal personhood can often be viewed as adjacent to recognizing Indigenous sovereignty and decision-making, particularly where Indigenous peoples are minority decision makers for the entity. How central is it to have Indigenous peoples as equal decision makers for these new legal entities? I don't know who wants to start.
I might start just because we have quite a unique situation in Tūhoe, but thank you very much for the question. In Tūhoe, the board actually started off as 4 government officials, representatives on the board, and over 4 years became 6 Tūhoe and 3 government officials, which is very unique here in Aotearoa, having the majority be from the land. And it's absolutely central to this paradigm shift. So essentially the legal personhood concept of the land owning itself and the humans belonging to the land or being friends with the land comes from a Tūhoe worldview and is recognized by legislation. So yeah, don't want to take up too much time.
I might just add to that, Erin. I think in settler colonial societies, it is crucial that the recognition of nature as a legal person or of its living entity status, that this needs to be led by Indigenous peoples. The Birrarung is not as powerful an example as Te Urewera and as Wanganui because it's not a 50-50 shared governance arrangement for the Birrarung. But the shaping of that legislation, the language in the legislation came from Wurundjeri Woiwurrung people, and they continue to shape the way the river is governed today. I think it's just not legitimate in settler colonial societies to try and undertake this work unless it's being led by Indigenous peoples, because as Erin says, they're the people with the intimacy of that relationship with the land, with the rivers, in order to know it best and in order to ensure that its voice is heard in that legitimate way. So yeah, I think that's a great question, and Indigenous leadership is central.
And just to add to that, Erin, I would say that in general, across the world, Indigenous peoples, no matter in which case, have been very generous in sharing a lot of the knowledge in moving some of these cases forward. But also kind of as a flip side is that the caution of how sometimes these cases have actually been tried to be used against some of their rights to the land. So there is always kind of this delicate balance to play and to have in mind when thinking about these cases moving forward.
Gabriella, do you have a comment you'd like to make?
I agree with recognizing the leadership of Indigenous peoples, but I also think we have a role to play when it comes to defending nature. In our case in Colombia, only 3 of the 25 plaintiffs were Indigenous, and we received some critics of people who opposed the decision from the Supreme Court saying that it wasn't a case led by Indigenous peoples. So I think it's important to collaborate, but it's a responsibility we all have by living in this planet. So I recognize the leadership, but I think it should be a concern of everyone, being Indigenous or not.
And Paul, would you like to say something about the Global Summit? Because I think it's really apropos to this question. The Youth Summit?
Well, one of the observations and I would say motivation behind the Global Indigenous Youth Summit was a dialogue with those communities that have been resilient in the face of change for millennia. And, you know, the question really about sustainable development, we have the 17 Sustainable Development Goals. The question of sustainable development operates across generations. I mean, across generations is a fundamental feature of sustainable development. So the issue is, how do we as a world operate across generations? Where is the leadership for us to operate across generations? And I would introduce, at least for discussion, that the concept of across generations is best suited for those individuals and those cultures that have been resilient in the face of change across generations. And on a planetary scale, those communities are indigenous. And reaching out to the indigenous youth is, in a sense, reaching out to the bridges, because the youth have both the skills, as excellently presented today by the leadership from the panel. They have skills with law. They understand the dynamics of how to operate in a Western world per se, but they also have the touch to the indigenous communities that have been resilient in the face of change. And so I don't think it's a question of majority or minority. I think it's a question of stewardship. And where do we as a world find the capacity to operate across generations?
Okay, thank you. There's another interesting question, many interesting questions, but I'd like to, maybe this might be the last one. Are these lawsuits mostly against governments, or do they involve corporations? Like in the Colombia case, for example, how do these rulings affect corporate activities?
So
Fiala, maybe you'd like to.
from what I've seen, and I recommend the audience to go to the Savings Center for Climate Change Law to understand better climate litigation cases. Most of the cases that I know on climate litigation are against governments. In the implementation, I would say they are not currently affecting private sector activities, but if you take seriously, or from my perspective, if you take seriously what rights of nature means, I would expect regulation, and I would expect that private companies considering that you're dealing with a new entity and that their rights need to be part of your considerations. From what I know, there are no cases against private sector, but maybe Lydia knows better on the rights of nature movement.
I was gonna say, in Spain, there is some actions that have been taken on this basis against some of the pollution that is being diverted to the lagoon, but they are still ongoing, so we will not know yet what will happen with the cases, but yes.
Okay, well, for those of you who asked questions, put them in the Q&A. I'm really sorry. We obviously ran out of time. We could have used another hour at least for this important discussion. And I would like to thank everyone who contributed here today, all of you, for raising our consciousness about how important it is to understand our relationship to nature and re-examine that, reframe that relationship to nature. So thank you very much. And you can see there's some upcoming events here at the program on negotiation. And our last seminar of the semester on May 7th is an interesting one about the relationship between the media and peace activities in the world. Instead of focusing only on conflict, how can the media contribute to peace by looking at and educating journalists as to how to report on peace issues? So anyway, peace projects and peace, anything related to peace. So tune in on the 7th of May, same time, and you'll hear Jamil, Andrea, and Stephen Youngblood talk about this very important topic of our relationship to the media and peace building. All right, thank you all for coming, and we appreciate your time. And again, once again, thank you for all our panelists for contributing today. Thank you.